Hi everyone, Jens Johansson here, founder of J2 Building Consultants, experts in providing solutions to building owners on how to repair and maintain their buildings. From the smallest to the tallest, we've spent the last 25 years understanding buildings and construction. Welcome to another free video educational series, and in this video we're going to talk about construction litigation and what that litigation process looks like. With all our educational videos, we've found that simply talking to you in this conversational manner is much better than the glitzy promotional video editing and fly-ins and glamour that we can do with software these days. So just imagine I'm in your conference room or I'm talking to you on the sidewalk in front of your building, and we're going to talk about this process. So let's get started. A lot of our customers are either building owners or maybe condominium owners or commercial owners, and they'll say, I think I've got a problem, when do I call an attorney? And so that when becomes once you know you have a problem. And that can be either, for instance, on a new building, something is leaking and it's brand new, it shouldn't be leaking. And we come in and we do an investigation and we say, whoa, something wasn't installed right and you've got a big issue here. Or if we are just doing some type of annual inspection, for instance, or a kind of a every 3-year type of inspection, and we come across other bigger problems, and we say, hey, you've got a bigger issue here, you might want to think about this. Maybe it's time to call an attorney, or maybe it's at the end of a warranty period and you're not getting any warranty response from the particular contractor, vendor, or supplier. That's the time when you know you should think about construction litigation. Then the next business piece comes in and says, is this a $10,000 loss? Well, don't worry about it. If it's a 6-figure, 7-figure, 8-figure issue, then you need to do what you need to do. And oftentimes that involves litigation. So what's the next step? Well, once you know the problem, then you need to call an attorney. And so our recommendation is that you call attorneys that specialize in construction litigation. So attorneys have lots of different practices, just like doctors. We don't go to our general practitioner for eye surgery or brain surgery. We go and find those specialists. Then they take it from there. They take the legal side from there. They have timelines, they have processes, they need to notify, they need to do the whole lawyerly thing. So let them do the lawyerly thing, but bottom line, find a construction litigation attorney that's experienced in that. What's next? Well, the attorneys are going to notify everybody that they think is involved based upon our original inspection. We're going to say these 3 or 4 issues, siding or walls or roof or foundation is a problem. They will notify those parties in that case. And so each one of those parties will then have their own expert, have their own insurance company, hopefully, have their own attorney. And so now all of a sudden you'll have anywhere from 3 to 15 parties in this litigation process. So all those other parties need to get up to speed. So they are going to do their own investigation. They may pigtail back onto some additional investigation that we've already had planned, or they may go out and say, well, it's not our issue that's leaking, it's that person's issue that's leaking, and we're going to demonstrate that that's the case. And so the biggest thing to expect is more poking and prodding of the building and the property, more questions, more costs. Everybody's building their case and trying to understand what's happening. The next thing is scope of repair. After everybody's done their investigations, they're going to say, well, here's what it takes to fix it. The plaintiff's scope of repair is likely going to be the largest and most comprehensive. And then each one of these parties are going to come in with their own scope. So if the roof guy, for instance, is writing a scope, he's probably really only going to write a scope that addresses any roof issues. He doesn't care about the other issues, and on down the line. So there may be, if there's 10 parties, there may be 10 different scopes. So that process needs to be managed and needs to be kind of manipulated and understood how those scopes interface with each other. Then those scopes are taken to the pricing stage. So Each party may bring in their own pricer. The group may agree on 1 or 2 pricing contractors, saying, here's the 10 scopes, give us 10 prices, or here's the plaintiff scope, here's the defense scope, somewhere in between, work up some prices for us. And then the parties come back through typically what's called a discovery stage. It's a process, and it varies by state, and it varies on their discovery laws, but it also varies on the parties' desire to resolve this. Do they want all the experts getting together? Some do, some don't. Do they want sharing of information, sharing of plans, sharing of photos, kind of a resolution sharing, open-minded approach, or do they want to all keep secret in their camps and then wait for trial and surprise each other during trial? It's been our experience that expert sharing and experts working together is a better approach on that. So that may involve some more inspections or testing. It may involve an allocation of responsibility. So here's 4 or 5 parties, but this one party really caused a majority of the problems, and here's why. The allocations come into the cost piece, and trying to portion out blame or cost to the relevant parties. At the end of the discovery process, or somewhere in between, there's usually a deposition phase where the experts are deposed based upon what they know and what they've found, in an attempt to make the trial process or the mediation process go more smoothly. Again, that's a state requirement, or a state rules guide some of that. So again, your attorney's going to be in charge of all that, but just so you as the owner know, of course, the discovery process costs, again, more time and energy because your expert's putting in more time and energy. And then we get down into a mediation or a trial. Most of these end up in mediation as a first step on their way to a trial or an arbitration. And a mediation is nothing more than a business meeting between the parties. They agree on a mediator who is a facilitator. And it typically happens in conference rooms in a law office somewhere, and the mediator goes between the parties and tries to get a deal done. At the end of that process, the parties make a decision, again a business decision, saying, I may not get everything I'm asking for at trial, but I'm also not getting a 0 verdict. Going to trial, you can win everything, you can win on some things, or you can get a big 0. So the mediation process is usually very effective. If that doesn't work, then it moves on to trial or arbitration, and again, lawyers and a whole big legal process. So then you end up at some type of settlement. At the end of this process, you'll end up with a settlement. So this is how the construction litigation process flows. These are the ins and outs of it from a consultant or from a consulting construction standpoint of what we need to do to help you through this process. And if you have any other questions on it, please contact us. Thanks for your time today.